Good day, Crime Talk aficionados. My name is Scott Reich, and it is Monday, November 22nd of 2021. And boy, we have a big docket for you today. First, Mark Means subpoenas the LDS Church. Why, you may ask? Apostasy. Second, the Ahmaud Arbery closing arguments are taking place, and well, it's getting ugly. Third, more rulings in the Ghislaine Maxwell by the court. The stage is set for her trial to commence. An Elijah McClain update. Andrew Coffey, does that name ring a bell? It didn't get a whole lot of news last week because there were some other things going on, but he was a black man accused of murder. Well, a jury said that he had acted in self-defense. A couple more examples of why you can completely lose faith in humanity, and then our dumb criminal of the day to lighten things up. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-driven, unbiased true crime channel. That's right, a channel where a practicing criminal defense attorney, that's me, explains the facts, procedure, and the law regarding current as well as cold cases. Now, if you haven't already done so, please hit that subscribe button, hit the thumbs up, hit that little bell so you receive notifications of when we go live, and as always, leave me a comment below. Now, don't forget, if you can't watch, you can always listen to the show as well as past shows by downloading Crime Talk on all of your favorite podcasting apps like Apple, Spotify, iHeart, Android, Amazon, and Audible. Now, before we get to the docket, we have to pay some bills. So let's support the people that support Crime Talk. Please go to crimetalkprep.com where you can claim your 3-month emergency food kit. Now, in today's world of supply chain shortages and, well, basically chaos in the streets, sometimes you have to wonder, well, what the heck is really going on out there? You need to be prepared for the unprepared. So go to crimetalkprep.com, get your 3-month of an emergency food kit, and you'll save $100. Now, you don't have to buy 3 months. You can buy a couple of weeks, a couple of days, but that's the best value right now. So go to crimetalkprep.com. You'll be happy you did. All right, on to the docket. Today is Monday, November 22nd, 2021. And well, Mark Means is at it again. Now, what could Mark Means be up to? Well, he is at it again for sure. Why? Well, he has filed some more subpoenas ducis tecum. Now, what does subpoena ducis tecum mean? It simply means a subpoena to produce certain documents. That's the ducis tecum part. And who did he subpoena? The Church of Jesus Christ of Latter-day Saints. I think they refer to themselves as the Mormons. That's right. And so what Mark Means is doing is he is subpoenaing, and he's asked the stake president, Mr. William Dowling, and to the person, Mr. William Dowling, you are hereby commanded to provide as instructed below the entire file, books, papers, documents, communications, correspondence, photos, videos, recordings, notes, charts, emails, text, telephone recordings, telephone calls, recordings, telephones, and other tangible things as it relates to witness identification, participating members of counsel, witnesses' identifications present for counsel, whether tangible or intangible, regarding the withdrawal of membership and or excommunication of defendant Chad Daybell. Okay. Now, it's rather interesting because, obviously Lori Vallow made a call from the mental state institution hospital there and allegedly also contacted the LDS Church. And so, of course, there's going to be further litigation about that. But it's actually quite interesting is that Chad Daybell apparently received a letter dated July 14th of 2020. And it's, Dear Brother Daybell, this letter is to notify you that the stake presidency is holding a membership council in your behalf, and it'll be held on a particular date certain. They will consider the evidence of apostasy, including promulgating teachings and doctrines which are contrary to those of the Church of Jesus Christ of Latter-day Saints. And he was invited to participate. The second letter, dated August 9th of 2020, was a letter by the President, William Dowling, to Chad Daybell, notifying him of the decision of the membership council that they held on August 2nd of 2020. And the council's decision was to withdraw your membership in the Church of Jesus Christ of Latter-day Saints for conduct contrary to the laws and order of the church, specifically for apostasy and for promulgating teachings and doctrine contrary to those of the church. Apostasy, what does that mean? Basically, rejecting the teachings of their church, kind of going his own way. So apparently, Mark Means believes that there is something of relevance as it relates to why Chad Daybell would be excommunicated from the church. I'm not sure why Mr. Means is going there, but obviously he has a little more information than we do. At least we would think so. But once again, I don't know if the co-counsel, that's right, Mr. Archibald, is encouraging this or whether he is just letting Mark Means go off on this tangent. The fact that Chad Daybell was basically excommunicated from the church for rejecting the teachings of the Church of Jesus Christ of Latter-day Saints would probably be something that the defense probably would want to keep out of any trial. So I'm not exactly sure why he is going there. I mean, I guess you want it here. But once again, we're back to, I think there's a difference between civil attorneys as well as criminal defense attorneys, okay? Sometimes there's just things you don't want to know, and it's probably not going to come in, and you would want to keep this information out that Lori Vallow and Chad Daybell basically probably booted out. Lori Vallow, not so much at that point, because I don't think she was really connected to this congregation, if that's the word that is appropriate in this circumstance. So, but the LDS Church would probably excommunicate her as well if they could have, or maybe they will in the future. But once again, Mark Means is at it again. You just never know where this guy is going. It's kind of odd to me that he goes off on these tangents on stuff that is really not relevant as it relates to the elements of the offense. In all honesty, it's just he's chasing his tail. Now, John Pryor has given notice that he wants to, he says that he shall bring forth his motion for discovery concerning events that were revealed in Lori Vallow's motion dated October 27th on December 2nd, 2021 at 1 p.m. So we're going to have a hearing again. Once again, John Pryor, and maybe it's just the way they do things in Idaho, but he's like, okay, we're going to bring forth this motion that hasn't been filed yet, but I'll file something before that date. Trust me on that one. It's just very kind of weird. I really just don't understand why the judge doesn't say, and this is the way it's done in most jurisdictions. I'm very, very surprised. A judge will say, all motions need to be filed by a date certain. If you don't file by a date certain, you have to show good cause and basically ask for a motion for leave to ask the court to consider a motion past a deadline. I don't understand why the judge is not doing that. It just seems like we're doing this piecemeal thing and nothing is ever getting resolved in this case, and somebody needs to take control of the Lori Vallow case. I know they're not going to get rid of the judge, Judge Boyce, but the reality of it is, come on, guys, let's get serious about this. This case can proceed, even with Lori Vallow in the mental health institution being restored to competency. It can proceed as to Chad Daybell. The attorneys can basically participate. They can prepare. They can be present. And then when Lori Vallow, if and when she's restored to competency, a lot of those issues can be resolved. But it's going to be able to move forward. Right now, it is just in a holding pattern, and it doesn't need to be. The state needs to get their act together. They're the ones that indicted. They're the ones that are seeking the death penalty. And when you indict, you say, the state, the government says, I am ready to go to trial within the speedy trial clock. Make it the defense to move to continue. But the prosecutor, when you indict, you say you're ready to go. And right now, we're just seeing delay on everybody's part. And frankly, somebody needs to get motivated over there, and let's get these cases resolved. Obviously, Lori Vallow is not going to go forward without her being restored to competency, but Chad Daybell can. And instead of the government whining about what jurisdiction they're going to be having to present their evidence on, and they may have to do it twice if there's 2 trials, guess what? The second trial, you've perfected it on any mistakes you made the first trial. So let's move ahead there, prosecution, in the Lori Vallow, Chad Daybell case. All right. Next on the docket, the Ahmaud Arbery case. Well, the jury is expected to begin deliberating the fate of 3 Georgia men charged in the fatal shooting of Ahmaud Arbery after this final arguments are resolved here today. Now, the arguments follow 10 days of testimony from 23 witnesses. The defense rested Thursday. Lawyers and the judge worked Friday on jury instructions. And as you can see, not only from this case, but other cases we have talked about, the jury instructions are usually never that straightforward. Everybody has to argue. Everybody has to make a record. Now, Jason Sheffield, the attorney for Travis McMichael, began his closing argument with basically was a statement of duty and responsibility to follow the law and always be intertwined with a heartache and a tragedy. Now, he added this case is about 3 things. It's about watching, it's about waiting, and it's about believing. Now, Sheffield added that Travis McMichael spent nearly a decade in the United States Coast Guard learning about duty and responsibility. And he said around the time that Mr. Arbery was killed, the neighborhood at Satilla Shores was experiencing an increase in crime and suspicious people lurking in the neighborhood. He cited the testimony of several residents of the community who testified, and Sheffield directed the jury to the encounter with Travis McMichael had with the man who he later identified as Arbery outside of his home under construction in the neighborhood that Arbery was last seen several times on security video. Now, Sheffield said that the offense of burglary doesn't have to constitute a break-in or a broken window or a busted door. I totally agree. Now, the other defense attorney that I was watching just prior to doing this recording, let's just say she was doing her job. She is a defense attorney, and she was laying it out there and basically said, hey, Ahmaud Arbery, without saying he's a criminal, well, said that he was a criminal. Said that he was out lurking around in this neighborhood. He was not a jogger. He was not there. He didn't have running shoes on. He didn't have socks on. He had on khaki shorts. Usually not what you wear when you're out for a leisurely jog for exercising purposes. Now, that's the argument that has been made. And she was also stating that Mr. Arbery, basically, although he's a nice looking good kid in the picture, that, well, he is maybe not exactly the kid that his mom wants everyone to believe he is. Taken a few swings for sure. Now, she also went into the whole definition of what is a burglary and whether it's basically a citizen's arrest. They're trying to say that you have to wait for the police. Well, they're saying they're going to blame it on Mr. Arbery. Now, no one should be shocked and appalled. That's what they're doing. They're arguing the reasonable inferences from the law and the facts that go along with the case at hand. That's what the defense attorney is going to do. So before everybody gets into a big outrage, all right, the prosecutors have already gone, and they always get the final closing. But the prosecutor, Linda Dudkowski, began her closing argument by telling the jury that the 3 defendants chased and killed Arbery based upon assumptions and decisions made in their driveway based upon a rumor and neighborhood gossip. She said they made their decision to attack Ahmaud Arbery in the driveway because he was a black man running down the street. That's according to the prosecutor. Then the prosecutor told the panel that all 3 defendants are guilty of the crimes that they are charged with. She said that the evidence shows that McMichaels and Bryan used their pickup trucks to falsely imprison Arbery, that Bryan admitted to the police he tried to block Arbery several times and once ran him into a ditch during a 5-minute chase. She cautioned the jury that the defense will make it seem logical that it was reasonable for 3 men on trial to be scared of Arbery and that he was attacking them and that Travis McMichael had to pull out a shotgun and pull it on Mr. Arbery. They're going to make it seem so reasonable. Put on your critical thinking caps is what the prosecutor said. Use your common sense when they're up there giving their closing arguments. Now, the DA went through the evidence piece by piece, telling the jury that at no time did McMichaels and Bryan ever mention to police on the day of the killing that they were attempting to make a citizen's arrest or that any of them actually ever saw Arbery leaving a house under construction in the neighborhood. She noted that the requirement for making a citizen's arrest is to witness a felony take place or at least have direct knowledge of one having occurred. She asked the jury to reject Travis McMichael's testimony that he, his father, and Brian chased Arbery down and shot him in self-defense, saying you can't be the initial aggressor and then claim self-defense. And this is where the law of self-defense gets tricky. Each state has its own nuances. Some places you can be the initial aggressor and still claim self-defense, but you have to withdraw. Really is a question of fact for the jury. Now, the jury is expected, obviously, to begin deliberations probably Tuesday morning, but they may actually get it this afternoon. So whether the jury starts deliberating today or early tomorrow, I would anticipate that they are done before Thanksgiving because they probably don't want to come back the day after Thanksgiving to continue their deliberations. However, one thing is certain, nobody knows exactly what the jury is thinking or exactly what the jury will do. And whatever the decision is, well, like I said, you're not going to change it. It will be what it is. So you have to go with it. We'll respect the decision either way. And if we are able to, we will bring you the verdict live when it happens. We've had some reasons we couldn't bring it to you throughout the week, but we'll see if we can't bring you the verdict when it happens. All right, Ghislaine Maxwell. Exactly a week before the start of her sex trafficking trial, Ghislaine Maxwell received permission to call a false memory expert relied upon by Harvey Weinstein, Robert Durst, O.J. Simpson, and hundreds of other criminal defendants seeking to undermine the credibility of the accusers. Now, Elizabeth Loftus has questioned the reliability of memory and how she believes suggestion can mold it. She's also testified about her research during the trials of Jerry Sandusky, Ted Bundy, and Paul Shanley. Now, I've never used this particular false memory expert. Frankly, I never have. I think that attacking a witness's recollection on the stand is much more credible than an academic coming in and saying, ooh, memory fades. Memory can have suggestibility, meaning somebody can suggest something to you, and after all, you may believe it. And usually that comes out. I don't think you've ever used it. I actually did a retrial on a case that got reversed on appeal. I didn't do the first trial, but I won the second trial. And the first one was a false memory expert. I don't think it's particularly effective, but each attorney's got to do their own case. Now, in a 2-page order released Monday morning, the judge, District Court Judge Allison Nathan, granted Maxwell permission to call Loftus subject to certain limitations that we don't know exactly for sure because they're under seal. And then Judge Nathan ruled that the prosecutors can call clinical psychologist Lisa Rocchio, who is expected to testify about the process of grooming minors for sexual abuse. Now, in the same order granting Loftus' testimony, Maxwell's defense received the green light to call someone to undermine Rocchio's testimony, and that's Park Dietz. Now, Dietz is a forensic psychiatrist who rose to fame during the case of Ronald Reagan's would-be assassin, John Hinckley Jr., who was ultimately acquitted by reason of insanity. Dietz is being called here to question the prosecution's claim that Maxwell groomed her alleged victims. The judge grilled potential jurors last week regarding her trial, which is supposed to start November 29th, and they whittled the pool of 600 down to just 58 potential jurors. So once those 58 jurors are brought in, the parties will be able to conduct a little further of voir dire to make sure there's no challenges for cause, make sure nothing else has changed. Then the parties will exercise their peremptory strikes to get down to the required 12 jurors plus the number of alternates the court has allowed. You can get rid of a juror for just about any reason on a peremptory strike, except for getting rid of somebody regarding their race, religion, and any sort of protected status, so to speak. Normally, it's just because you don't get a warm, fuzzy feeling and you don't like it. I always like to ask my clients if there's somebody that you don't like so that I can get rid of them. And obviously it gets tougher when you get farther down and you only have a limited number of peremptory strikes and there's still a lot of people you want to get rid of. So you have to pick kind of a lesser of evils. Who is the worst person you want to have and get rid of? Hopefully this will work out. We have a great jury and both sides will get a fair trial. We'll just have to wait and see. All right, next on the docket, an update regarding Elijah McClain. Now, if you all don't remember this case, we talked about it several months ago, and I said, well, the city of Aurora here in the state of Colorado needs to get their checkbook ready. Well, they did. $15 million. So the city of Aurora is writing a check for $15 million, 10 of which is coming from the city's insurance company, another 5 from the citizens of the city of Aurora, for a total of $15 million to settle the civil rights lawsuit regarding the wrongful death of Elijah McClain. Now, he's a black man who died in 2019 after he was detained and placed in a chokehold by police, then given a sedative that led to his cardiac arrest. Now, what's troubling about this case is it was all on video. I think we've actually got the videos up, and Elijah McClain was doing nothing wrong other than he looked suspicious, or in some circles they say, walking while black. There was no reason to stop this guy. Anyway, now the settlement ends a lawsuit that was filed back in August of 2020 by McClain's mother and father against the city, and 12 of its police officers, 2 fire department paramedics, and the fire department's medical director. Now, this case has led to criminal charges, including manslaughter and criminally negligent homicide, 3 police officers and 2 paramedics. And that was announced by the Attorney General because he had a grand jury convened to see if there was enough evidence to go forward. And the citizens of the grand jury could have rejected it, well, kind of. But the reality of it is they said there was enough evidence for the case to go forward, and a jury will decide the case. Now, let's talk about Andrew Coffey. Who is Andrew Coffey? Well, he didn't hear much about him. There was some other news going on at the end of last week, but he was a black man, and he was found not guilty of all counts of murder and attempted murder on Friday, and he was accused of firing at the Indian River County Sheriff's deputies during an early morning drug raid at his home back in 2017. Now, his girlfriend, Alteria Woods, was caught in the crossfire, shot 10 times, and later died. Coffey was charged with the murder of Woods after a grand jury exonerated 2 of the law enforcement officers for her death. And before the case went to the jury, Coffey took the stand to defend himself, blaming deputies for his girlfriend's death. The defense said Coffey was asleep and thought the flashbang was gunfire, so he fired his gun because he thought he was under attack. He stated, quote, "I was trying to protect me and Alteria, and I thought I was doing that, but I feel I didn't protect her. I can't sleep with that. They killed her," according to Mr. Coffey's testimony on the stand. Now, the prosecutor said the deputies did announce that they were there. They said Coffey fired at the deputies and they returned fire. Coffey was found guilty of 1 count of possession of a firearm by a convicted felon, which could have a penalty of up to 30 years in prison. He was also found not guilty in the murder of Miss Woods. Now, the Indian River County Sheriff, Eric Flowers, released a statement following the verdict and said it's disappointing the jury did not see the tragic death of Alteria Woods occurred as a direct result of the actions of Andrew Coffey. Our hearts go out to the Woods family as they still suffer from the loss of their daughter, but we stand by a statement that she would still be here had Coffey simply complied with law enforcement. And just goes to show, ladies and gentlemen, each case is different. Each state has different law to apply to different facts. But guess what? The American jury system, in my humble opinion, although flawed, and oftentimes people say it's absolutely terrible, but it's better than anywhere else in the world, usually gets it right. All right, now let's talk about a couple of cases that will completely destroy your hope in humanity. And this kind of stuff, it just is shocking, ladies and gentlemen. A homeless man has died 13 days after a New York public housing resident set him on fire as he was sleeping in the stairwell. The man, whose identity has not been established, suffered burns over 75% of his body just before 5 p.m. on November 5th, when security footage showed a man using a lighter to set his pant legs ablaze before running off down the stairs. Now, police identified that man as 27-year-old Nathaniel Terry and arrested him on charges of attempted murder, assault, and arson. The charges are going to be upgraded, though, when he returns to court on December 9th to murder. Investigators said the victim regularly slept in the stairwell and hallways of the Pitt Street Samuel Gompers housing building, and that they initially thought he'd set himself on fire when they found a crack pipe nearby. Now, Terry reportedly told investigators he was just trying to scare the man off when he lit his pants on fire. As the video shows, and the victim, believed to be in his 30s, was quickly engulfed in flames. Other residents extinguished the fire. Okay, ladies and gentlemen, I get it. Why do you want somebody sleeping in your stairwell? I get it. You don't. But you have to get them to go out on their own, or maybe with some assistance with the police for trespassing. You can't light somebody on fire, okay? That's just crazy. You can't do it. It's not right. And why you think that it would be a good thing to do, or even a way to scare somebody? Yeah, you did. And they're now burned. Even if the guy's a crackhead, he doesn't deserve to be burned alive. Just because he's sleeping in the stairwell doesn't mean that he deserves to be burned alive. All right. Next, mass lootings. If that doesn't just absolutely destroy your faith in humanity, what will? So Bay Area looters have coordinated by the dozens and descended upon high-end retail stores. Video taken at a Nordstrom store in the upscale East Bay. About 25 cars just blocked the street, rushed into the Walnut Creek Nordstrom, making off with goods before getting in cars and speeding away. At least 2 people were arrested at gunpoint. Now, most of the looters hopped into cars and got away, but the Walnut Creek police did arrest a few following the flash mob robbery. 3 of the reported 80 people involved in the looting were arrested, and it's apparently becoming a trend in this neighborhood of San Francisco. As just the night before, tons of people broke into a Louis Vuitton store down the street and ransacked the place there as well. This is far from any California-only problem. There's been reports of mass lootings all over the country for the past several days now, including areas near Chicago, as well as another Louis Vuitton store was cleaned out. And there was another incident that just happened at Sam's Jewelers, which is in the mall in Haywood. And this was caught on camera as well. We've had Lululemons that have been hit. And once again, ladies and gentlemen, it's not your stuff. You can't take other people's things. Now, what is the cause of all this? Well, it's like anything in life, ladies and gentlemen. You get more of what you tolerate. If there are no consequences, people are going to do it again and again, right? Criminal justice, right? Punish, deter, rehabilitate. I'm not sure we're doing any of that anymore when people literally can go in broad daylight or right when the store is closed and loot the store and have no worries. The store's not doing anything. They're just letting it go. I guess everybody thinks, well, they just have insurance or they're self-employed. They must be rich. Not the case at all. This is just absolute lawlessness, and somebody needs to put a stop to it. And oh, by the way, maybe they need to change the law. So instead of making theft under $1,000 a misdemeanor, maybe you need to reduce that dollar amount and make it a felony again so that people get serious about, following the law. All right, next on the docket, our dumb criminal. Crime Talk's Dumb Criminal of the Day. While locked up in a Florida jail following a DUI arrest, a Florida woman, Susan Mae Shepard, removed the metal wiring from her bra and attempted to use it to damage the jail cell door and escape. Shepard removed the metal wiring from her bra and proceeded to use it to make numerous scrape marks into the glass on the bottom of the holding cell door. Corrections deputy reported the incident. Shepard also allegedly sought to crawl out of a small opening in the holding cell door, feet first, and had to be directed to pull her legs back into the cell. After being questioned on what she was doing, Shepard admitted to trying to escape because the jail was scary. 2 additional charges have been added to Shepard's docket: attempt to escape and criminal mischief.